This is House Planning Help episode 170. Hi there, I'm Ben Adam Smith, and this is the podcast for you if you're interested in self-build, because I'm exploring what houses we should be building in the 21st century and trying to break down the major roadblocks that may get in our way. Coming up in this session, my guest is Michael Campbell, an associate at Spratt Endicott Solicitors, and we're going to be looking at buying land. What exactly is involved in this process? Just before we get into that, remember that we've got a free course on the website for the stage before that, which is looking for land, just uncovering all those opportunities. It draws on the experience of various self-builders who've been there and done it, and helps you with things like, what do you actually need? What can you afford? What are the plot types that you might consider? How do you start your research? It's obviously the easy way, the right move way, but perhaps you want to try and uncover a plot which will be more affordable if no one else is in competition with you. Then there's the planning angle as well, lots more packed into this course. If you haven't been through that already and you're coming up to that stage of needing a plot, then I'd definitely say go and have a look. The Finding Land course is at houseplanninghelp.com/land. Michael Campbell is an associate at Spratt Endicott Solicitors with lots of experience, as he's about to share with us in a moment. Now, I'm going to use this interview as a debriefing session from my own purchase. I understand a bit more about the process now, so hopefully that will help me ask some better questions and give you a clearer understanding of the steps that you need to take once you've found that perfect plot. Or perhaps not so perfect plot, but you want to buy it anyway. So I started by asking Michael to tell me a little bit about his background.
I'm Michael Campbell. I'm an associate solicitor here at Spratt Endicott, dealing with development, residential development mainly, but also some commercial development. By background, I've always been in the residential development game, as it were. I spent nearly 20 years at a national house builder as their in-house lawyer, dealing with all their acquisitions, sales, affordable housing sales, infrastructure agreements, planning agreements, anything really that gets a site from a bare piece of land to a finished housing development.
How different is it from self-build to volume house builders acquiring land?
The principles are essentially the same, in that there are a number of factors that when you buy any parcel of land for the purposes of development, you need to take into account. I think you can probably break those down into, simplistically, probably four different aspects. Firstly, you've got your title that you need to be certain of. You've got your access. You've got your services / drainage, and you've got your planning. And those are the, as I say, services, drainage, kind of combined, but so it's 4/5 separate topics that you need to be concerned with.
When we're dealing with our solicitor, what are the actual legal steps that you're going through? And this may have been what you've just covered, but I engage my solicitor. What happens next in terms of if this was a very smooth purchase of land?
Well, your solicitor would obtain the title. He would also put in hand searches. I didn't really mention searches in the preamble there because they happen on any transaction. They will be things like your local search, your drainage search, your chance of repair search. They will be the things that he would carry out as a matter of course. And if any issues arose in relation to those, then you would either insure against an issue that arose, or if it was that drastic, you wouldn't be able to proceed with your purchase. I think in terms of an additional search that he would carry out, particularly when you're buying a plot of land, and it's where I mentioned the access point, is you would carry out a highway search, because you need to be certain that the adopted highway abuts the land that you're looking to acquire. No point having a lovely parcel of land that you're going to build a house on if you can't actually get to it. So that's one of the searches he would carry out, and access is a very important aspect of any purchase. It may not be quite as simple in terms of access as it abutting a highway. It may be that you're buying a piece of backland, maybe somebody's rear garden, something of that nature, behind a farmhouse, whatever it might be. And that's where the title comes into play, because you need to be certain that the title allows the access to take you from the adopted highway to where you want to go. It may be that within the title deeds, for example, there's a restriction that says that the access that you've got can only be used for the purposes of one dwelling. Well, if it's already being used for a dwelling, using it for your additional dwelling that you're about to build would actually be a breach of a covenant that exists on title. Something that either you're able to insure against, or could be something that means that you can't proceed with the purchase of the parcel.
We had 3 titles that formed our overall piece of land, and that obviously is a little bit confusing just to start with. Now, one of them was a different band to the absolute. I believe that's what you want, isn't it? It was a title possessory.
Yes, you want your best class of title that you can have is absolute title. With possessory title, you always run the risk that someone with a better title than you will be able to come along and claim the title to the land in place of yourself, which of course, if you're building on that particular parcel of land, could be a disastrous scenario. You would normally back up your possessory title with an insurance policy, so that if in that scenario, insurance would either cover compensation to the person who's been, quote, dispossessed of their land, or alternatively would be paying you back the costs that you've incurred in purchasing and whatever development you may have carried out at that point on the land.
How do things become possessory? This is what I can't quite understand. That deeds just go missing. I mean, the deeds check into the land registry. Have I got that right?
They do, but they only check in once there's been a transfer of land. That became compulsory in 1987 in England. But there are still large areas of land which have never changed hands in the last 30, 40, 50 years and are still unregistered. If title deeds get lost, but somebody believes they own a parcel of land, they will submit their statutory declaration to say, I've always used this piece of land, and at that point it becomes registered with possessory title.
And the title can change after a period of 12 years?
Yes, you can apply for it to be then upgraded to absolute title on the basis that nobody has made any claim better than your claim to be the owner of that parcel of land.
Are there any other titles that we should know about?
No other titles to know about, but in terms of your title, when you're buying a piece of land, you want to be certain that the title doesn't have any rights or covenants on it which would affect your ability to build the development that you're looking to build. Taking the point I made earlier about buying a piece of somebody else's garden, for example, to build another house, again, if the title was to state that no more than one dwelling can be built, then obviously your second dwelling is in breach of that covenant. In those circumstances, again, you would be looking to, insurance is mentioned a lot, but again, you would be looking to obtain insurance to cover off that potential risk.
In terms of insurance, then, is it easy to obtain? I mean, they've got to manage against their risk, haven't they?
Yeah, I mean, it's relatively easy to obtain. It's not always, you can't always obtain it, but generally speaking, you can obtain insurance. What an insurer is most likely to do in those circumstances is you're looking presumably to buy this parcel of land, get planning and build a house on it. They will often do their insurance on a subject to planning basis, i.e. what they're saying is if you go through the whole planning process, you get planning permission and no one has come forward to claim that you can't build your house because of the covenant, then they will give you insurance based on the quote that they've given you, which is based on a value. Like all insurance, it's based on a value. You know, a Ferrari is more expensive than a Mini to insure. It's the same principle with a house. The bigger the house, the greater the risk, the greater the insurance.
Can we rewind back to the searches that we talked about early on? Because when we received the searches back, it was almost a little bit confusing that they were saying, nothing's come up as far as we're aware, but we can't say any more than that. Is that quite common that they're just saying, well, it's a sort of tick, but I'm not going to put my word on it? Or
the search is on the property that you're acquiring. It's not telling you it's something that might occur 100 yards away, for example. It is purely relating to the property. As long as that is clear, then you should be happy with that. If you want to know more, then you make further investigations of the local authority.
I'm just going to bring up a few examples of things that have happened as we went and tried to appraise various different pieces of land. So it'd be interesting just to get your comments on that. On one, we were very, very close to buying it until we found out about this uplift of value. So let's say it was a garden plot, and we thought we'd done our due diligence and really knew what we were getting ourselves into. Is it called overage?
Overage, yeah. Overage occurs where somebody who sold the land that you were seeking to develop on had in the past recognised that there was potential for development in the future, and therefore requires an uplift in the value of that land once it has got a planning permission for that development. You know, if you take an agricultural value, that might be worth, I don't know, 6,000-8,000, something like that, an acre. But with a planning permission for residential development, it's suddenly worth, you know, whatever it's worth, 200,000, 500,000, $1 million, depending on how large the parcel of land is.
This one was quite interesting because it actually wasn't the existing owner, it was the people beforehand. Yeah, so it would just go on and on?
No, so it will be a previous owner who will have, as I say, he will have sold the land to the existing owner, but he would have recognised at the time he was selling it that there was potential for either the new owner or an owner in the future to get planning gain, as it were, in respect of that parcel of land by getting a planning permission for something other than its agricultural use. So that is not unusual. The overage could be put on for 10 years, 20 years, 50 years even. There's no limit on how long the overage can last for.
And there's always a trail back, even, 50 years is a long time.
But the trail is there because there was a restriction put on the title by that initial owner that alerts anybody who's about to purchase the property that their consent is essentially needed to that sale taking place by way of a payment being made to them or their successors in title, as the case may be at that appropriate time.
Another piece of land was a very odd one that it actually turned out to be a leasehold. And the leasehold was about 25 years, 30 years long. Now, I think that this is probably a very unusual case because it dated back 500 years or something along those lines. And the whole village operated like this. But would there be any sense at all, we obviously steered clear of it, of going into that? Or
if there's only 25 years to run, then not really, because you wouldn't get a mortgage on it.
Because you probably could have got quite a good deal. It was an acre plot in a nice village, but it's about sale, isn't it? Afterwards, that's where
it's about resale. It's about you might be buying it for £1, but if you're going to spend 100,000, 200,000, whatever you're going to spend building a house, looking after that house for the next 25 years, only for it to suddenly in 25 years' time not be yours, then is that a gamble worth taking? There's no resale value in it.
This was something that actually came about during Henry VIII's era and had this 500-year leasehold on it. So what would happen when that expires, if a lot of these people are in that boat?
It would go back to, well, if it's Henry VIII, it will go back to the Crown.
Oh. Fascinating. So we talked a little bit about covenants earlier. Are there any other common case covenants that you might encounter?
I think if you're talking about purchasing a plot for the purposes of development, the most common you're going to come across is whether you can build more than one dwelling. The other one that you may come across is a covenant which requires your plans and drawings to be approved by a previous owner, or indeed the current owner, as to whether you can build what you're looking to build. It may even be that the person that you're buying the parcel of land off wants to be able to approve your plans and drawings, because if he's going to be living next door, he might not want you building something which he doesn't consider to be in keeping with his own property and his aspirations.
Easements?
Well, easements are a different thing. Easements take many forms, but The most common easements are going to be either easements for services running across the site or potentially an easement for a right-of-way or a footpath. The local search will have thrown up whether there are any public footpaths that run across the site, but you also need to be careful that a footpath hasn't come about by what's known as prescription, which is 20 years use, or there isn't something within the deeds that gives a certain group of people or area of people the right to walk across your parcel of land, particularly if it happens to be through your front door and out your back door. So you do need to be careful of that. I mean, your solicitor should check the title to ensure that that's not the case. Your own investigations when you're looking at the plot itself should be able to indicate to you whether you think there are any footpaths which cross the site, and if there are, you would raise an appropriate inquiry of the current owner to say, have people walked across it? Have you ever had to stop people walking across? And what's the position generally with regard to that footpath? A clue sometimes is, on larger sites admittedly, is where people have put gates in their own back gardens which take them across your site to walk their dog or something of that nature. Yes, I mean, footpaths and drainage easements are things you need to be concerned about, and I say they should be noted on title, but you would raise an inquiry in relation to whether there are any easements that arise which may not be noted.
When I bought my piece of land, a lot of upfront work was trying to see have I got everything, and then when you hire the solicitor, it's almost clarification. So, can you do all this work yourself to get prepared, or will the solicitor? It's part of the process.
It's part of the process. The solicitor. I think most people could pick up a title and see a covenant that says no more than one house, for example. I think you can do your own research to a limited extent, but taking your easement point, I think that's a little bit more complicated to understand as a lay person. And also sometimes the nuances themselves of covenants. A covenant doesn't always mean what it appears to say.
That's actually quite an interesting point as well, and down to the terminology, because often, and this is where you get involved, I suppose, that one sentence can be read two ways.
Yeah, well, I think that's right, and that's why I mean that you can read it, but you do need the solicitor to either confirm that your interpretation is correct, or actually say to you, no, that's not the correct interpretation. You have to read it this way.
How much of what you used to do was in terms of looking at budget, or at that point, they said, this is the piece of land that we want, here's the budget, and then you start the process, or is that all tied in with the planning and so forth? Because it's all connected, isn't it?
Well, it is all connected. I think if you're going into this process, you need to understand how much your planning is going to cost. You can work out your build costs. You will go to somebody, you'll have a pretty good idea of how much it's going to cost you to actually physically build the house itself. What people sometimes don't quite appreciate is how much the planning itself can cost them. It's often not just a case of submitting a planning application and saying thanks very much to the local authority. You often will need supporting documentations, for example, an ecology survey, perhaps a survey for contamination, ground investigations, all sorts of different surveys depending on the nature of the site, and those are not cheap. You could end up with a flood report or a noise report or a traffic impact assessment or anything of that nature which the local authority may request as part of your application, and it's that type of thing which can boost the costs.
Are there any other challenges or perhaps even stories or things that might come our way when buying land? For me, I've experienced a lot of these through land that I haven't bought, and then the one that I have bought, trying to think very carefully, has this got everything I need? Have we thought through this as well as we possibly can?
I think the basic process is always the same, but no two parcels of land are the same, and I think it'd be very difficult for me to say this will always happen or this will always happen. There is a process that will always occur, and that process is, as I said, you'll do your searches, you'll check the planning, you'll check the title, check the access, check the services, etc. But there will be all types of things that might arise within that investigation, which is different to the parcel next door. And that's just how it is.
And when we get to the point of exchanging, maybe you could just explain what that process is and why it's separated up from completion.
The exchange is it's one of those things that has a sort of mystique around it. An exchange is literally what it says. You, as part of the documentation, your solicitor will have put in front of you a contract which will say the seller's name, it will say your name, it'll tell you the details of the property, it'll tell you the purchase price, it'll probably have at that point a blank completion date to be filled in, it'll say whether there's anything else included within the sale itself, and you will sign that document. And once you've signed it and the seller has signed it in this particular scenario, the solicitors will literally exchange those contracts. They will have a telephone conversation, they will agree that both parties are entering into the agreement, they will date the agreement, they will insert a completion date, and then they will each send each other the other's part of that agreement. So your part as the buyer will go to the seller's solicitors, seller's part will come to the buyer's solicitors, and that is effectively what an exchange is. There may be a deposit that's changed hands. 99 times out of 100 there probably is a deposit that changes hands, and that will go across from the buyer to the seller at the same time. Completion is the date when essentially you move. So at that point, taking the parcel of land, the seller will ensure that that land's got vacant possession. For example, it may be that the next door neighbour has been grazing his horse or something like that. So that land will be, he will ensure that the land has got vacant possession. Your solicitor will hand over your purchase monies for the balance of your purchase price, and that's completion then takes place at that point.
What would happen if something came adrift midway through that? Are there any penalties? Let's say if you wanted to, no, I don't want to go through this, you've exchanged contracts, what happens then?
Once you've exchanged contracts, you are contractually bound. So if you wish to withdraw, unless the other party is agreeable to you withdrawing, then compensation would be payable. If the seller wants to withdraw, you as the buyer, well, in fact, both ways around you could do this, but you as the buyer would almost certainly apply for specific performance and try and force the seller to sell you the land on that basis through the courts. Quite a drastic step, clearly. Quite a drastic step, full stop.
So it doesn't happen very often, really?
It happens very rarely, yeah.
What about timescales for this? Are there any times when you might be more inclined to hit a deadline? How does that work versus, I've seen some that seem to go on for ages and ages and others that need to be turned around in 3 weeks?
It depends. To be honest, it's driven by the parties to the transaction. Often there will be a need why one person wants it done in a particular time frame, and it will be done within, as far as is possible, within that time frame. There's no set rules how long it's supposed to take, but I mean, I probably as an average, if you were to do this, you would probably say 3 months as a kind of average type of time. Some will take longer, some will be quicker. It's a swings and roundabouts type situation. As I said, no two transactions are the same. So, you might think it's a nice straightforward transaction, but if something, for example, arises on title where you have to think about an insurance policy, well, that might take a bit of time to sort out to everybody's satisfaction.
How often when you're going through all of this legal work, and let's say your title example, there's something comes up that people then pull out?
How often? Probably relatively rarely.
So most things you can solve.
Yeah, generally you can solve most things. If the parties want to solve them, then they generally can be solved. Yes. Obviously, the one that might not be solvable is if you if you can only build one house and it's quite clear one of the adjoining neighbours who has the benefit of that covenant is going to complain, that may not be solvable.
When we buy a piece of land, clearly it's going to cost a bit of money. But on top of that, we've got stamp duty. Are there any other costs, or maybe you could explain stamp duty and then anything else that might be coming our way? We've got the solicitor's fees.
Well, you've got solicitor's fees. You'll have your stamp duty, land tax, which will be based on the value of the parcel of land. You'll have a land registry fee, which again is based on the value of the parcel of land. Your search fees. Different local authorities vary in their prices to an extent, but you're probably looking at an average, probably somewhere between $750 and $1,000 for your searches when you carry those out, depending on what you want carried out. Some people will, if they haven't got a mortgage, will say, well, don't worry. Others will want the whole raft of searches. So again, that depends. But your solicitor can give you, a breakdown of what they are before he undertakes them, so that you can effectively pick and choose which ones you want to do. If you've got a mortgage, you've got to have a local search. You'll have to have a drainage search. Almost certainly they'd want to check the solicitor to be checking the highways, chance of repair. Those would be pretty standard searches which would need to be carried out if a mortgage is involved. But other than that, unless unfortunately you've got to agree between the seller and the buyer who's going to pay for the insurance, then they're really your costs.
Well, I think I've just about gone through a lot of the things that were on my mind for this. Does it get easier over time?
No, actually. No, I think, funnily enough, more and more things arise, I think, as the years go by, and therefore, I'm not saying it's necessarily more difficult, but I think there's certainly more complexity involved than there perhaps was 20 years ago.
Maybe finally you could just help us with some advice. How do we find a good solicitor? I've been impressed. Well, actually, you were recommended to me, but how would you go about that process? What would you be looking for?
I think you'd be looking for someone who, and you can generally do this on websites these days, you'd be looking for somebody who, if you're buying a parcel of land, you'd be looking for somebody who does that as a day-to-day job. Lots of solicitors will do it on an intermittent basis, and I'm sure they probably do a very good job. But you're probably looking, at the same time, you should be looking for somebody who does it all the time. It's horses for courses at the end of the day. If you're buying a residential dwelling, you go to somebody who does residential dwellings all the time. It's the same with land. If you're looking for somebody to help you buy a piece of land, you look for that person. Somebody who's more of a general practitioner. I say no reason not to use them, but you have to question how many times do they actually buy a piece of land during the course of a year, or not, or is the majority of what they do in residential house purchases.
Well, Michael, thank you very much for all of your information today. Really appreciate that. Cheers.
Thank you. No problem. Thank you very much.
Head online to take a look at the show notes that accompany this session. You'll find them at houseplanninghelp.com/170, where you can review all the main information from today's discussion. Perhaps you have a comment or a question that you'd like to ask, just scroll down to the bottom of the show notes. That's the place to do it. And we'll link you across to Spratt Endicott Solicitors, all at houseplanninghelp.com/170. If you got value from today's podcast or some of the other podcasts that we've had in our series, then please write us an iTunes review. It's very easy to do. It doesn't have to be long, but it will just help guide newcomers to this information, which we want to really get out there. So head into the iTunes store, look for House Planning Help, just search for it there, and then you'll see a section saying ratings and review, and that's where you can write a new review. Thank you in advance. Next time we talk interior design with Alina Gregoriou. So that's going to be a good one. We've never discussed interiors before. The House Planning Help podcast is produced by Regen Media, content that matters.